Hello. Can you hear me all right on this speaker? Yeah? Fine. I'm Peter Kellett. I have the huge honour to chair UKELA, and it's wonderful to welcome so many of you here to the Jack Garner Memorial Lecture. This is the time that we gather to celebrate the memory of Jack Garner, and I think he would have been pleased that we're not just going to hear from Sir Konrad tonight, but also we're going to celebrate great excellence in student achievement, and Liz Hatton will come up and present our award for this year. I do hope you enjoy the evening, and before I hand over to Liz and to Stuart Popham, the senior partner at Clifford Chance, I'd just like to say thank you to Clifford Chance, remind you of health and safety, doors here, doors there, there'll be an announcement, and also ask you to turn your Blackberries and phones off now. So if you dig now before we get going, because it interferes, and believe me, you'll hear it. So if a fire alarm is activated, you'll hear it too, as we assemble outside in the square. Enormous thanks from the trustees of UKELA to Clifford Chance for so generously hosting us here tonight. But with that, I shall hand over to Elizabeth Hatton and Stuart Popham.
Thank you very much. As Stuart Popham, Senior Partner of Clifford Chance, and the very simple but particularly pleasing task to welcome you all here this evening on behalf of all the partners at Clifford Chance. Welcome you both to Canary Wharf and to Clifford Chance in particular. And I'm sure you will enjoy the evening. And to be absolutely certain that you'll enjoy the evening, please stay after the presentations and enjoy some refreshment outside at the back of the hall there. We're especially pleased, I think, to be able to host this event for UKELA again, and the more so when we saw that the topic was focused on access to justice. I have absolutely no doubt that our clients, when they come and seek their advice from us, are able to draw on the commercial expertise of Nigel Howarth and his team on the environmental law group and other areas. But there are too many people who aren't able to afford or can't find access to justice. And by way of something of an introduction to this evening, just to ask you to indulge me just for 1 minute as I say to you, it's something that is particularly important to all of us at Clifford Chance. And we decided to establish the Clifford Chance Foundation in 2008 to bring a focus to our pro bono activity, to our giving, to our community engagement, and along with bringing a focus on access to finance and access to education, it particularly looks at access to justice, something that too often we take for granted. And there are just two examples that I'd like to share with you, because I'm particularly proud of what the firm has been able to do. The first is in connection with an organisation called Avocats Sans Frontières, ASF, who we've now made a 3-year commitment to finance and to help them run their organisation, bringing justice, bringing access to lawyers and legal representation in many, many countries around the world where otherwise it wouldn't be available. And then something that I hope will find greater news and people will become more familiar with it. We have created an annual award for access to justice, and this year, just last month, we awarded it to an organisation called the People's Legal Aid Centre in the Sudan, and people who are using their legal expertise, a small group of half a dozen people who are using their legal expertise in Darfur to help displaced, dispossessed people actually through the rule of law find some stability, and our ability to give them what's really a small sum of £50,000, but also to make sure that we're going to give them hours and hours of support, I hope makes a difference and brings justice and access to justice, which is so critical. So forgive me for making that point, but I think it's such a critical area that I'm really thrilled that we can be discussing this in respect of environmental cases tonight. So before handing back to Lord Justice Carnwath, perhaps I can introduce Elizabeth Hatton from the UKELA Council. Where'd she go? Sorry, over there. Facing the wrong direction. With the prize to award. Over to you, Elizabeth. Thank you.
Thank you very much. I'm delighted to be able to present the first UKELA Simon Ball Academic Prize for Outstanding Student Achievement, as sponsored by Oxford University Press. As many of you know, Simon Ball was a founder member of UKELA and actively involved in the association before his death at only 39 years of age in 1996. He's one of the first to teach environmental law as a subject, and with Stuart Bell authored one of the first and most comprehensive texts on environmental law, indeed a textbook that's still a cornerstone of the subject today. In Simon's memory, UKELA decided to set up this award to recognise and celebrate student achievement in the field of environmental law. The prize is open to any under or postgraduate and who has contributed to the advancement of environmental law or otherwise to the charitable objects of UKELA, be it through academic excellence or some other kind of contribution such as charitable work. This first year there was a strong entry from both those studying the subject and those applying it in a charitable context, and I'm delighted to award the prize to Elizabeth Muir from Strathclyde University, who's now a trainee at McGregor's in Glasgow, and she receives £250 of books from OUP and a subscription to the Journal of Environmental Law, as well as free UKELA membership for a year. Now, Elizabeth won with her undergraduate law dissertation on properly conceived environmental regulation, the drive towards the low carbon economy, which critically examines some of the orthodox thinking on emissions trading by looking at the wider context of regulation and competition law, and suggests that alternative approaches may better encourage innovation and indeed reductions in emissions. As judges, we felt that the depth of her research, her understanding of the broader issues and her boldness to challenge widely accepted concepts, combined with her very engaging and fluid style, meant that Elizabeth is a very worthy winner of this year's award. And I'd just like to invite Elizabeth to come and receive her prize.
Well, my congratulations also. It's splendid to see that award this first year in memory of Stuart Bell. Now, over to the Garner lecture, a very important element in the year and something which has had a range of very distinguished speakers over the years, but none more so than today's speaker, Sir Konrad Schiemann. He's very well known to many of us in the audience. I think I first came across him in Canby Island, of all places, back in the 60s, or 70s, it must be the 70s, I think, arguing about the environmental qualities of an oil refinery, which never got built. I can't remember whether that was because of his efforts or mine, but one way or the other. And then subsequently I had the honour to be led by him up in Manchester in a curious case about the health effects of microwave transmitters in the early days of that particular thing. And of course he mastered the science involved in all those things. He has a distinguished career, Cambridge University, and then becoming a barrister in 1964, Queen's Counsel in 1980, and then a Justice of the High Court in 1986, and a Lord Justice of Appeal in 1995. And he made an enormous contribution in all those capacities, and again I had the privilege to sit with him in the Court of Appeal. But then he became, one would have thought that might have been enough for most people for a career, but not in this case. He became a judge at the Court of Justice of the European Union in January 2004. He is the model of a European judge. He speaks several languages fluently. He lives in a splendid house overlooking the Moselle, and he has made a major contribution to the development of European law. The subject this evening is of great topicality in this country, as I expect it is in quite a number of countries, which is the influence of European Union law on access to justice in environmental cases. So I will ask Mr. Konrad to speak.
Thank you very much for that wholly exaggerated introduction. Part of it is downright lie. When he said I mastered the scientific aspect of the matter, my sole contribution was to say the scientific aspect of this case is totally irrelevant. You master it, which he did. Since the United Kingdom joined the European Union, and I use that term to embrace its predecessors, the various European communities, more and more authorities, non-governmental organizations, and individuals have been in a position to contribute to the decision-making process in environmental matters. By that I mean to embrace both the process of the appropriate authority coming to a primary decision on the question at issue, and also the process of challenging before the courts that primary decision. Union legislation has required that member states adapt their existing legislation first so as to permit a great degree of publicity for anticipated developments of one sort or another. Second, so as to entitle a variety of persons and organizations to have an input into the decision-making process before the decision has been made. Third, so as to oblige decision-makers to give reasons for their decisions. And fourth, so as to permit such persons and organizations to examine before the courts whether the decision-making process has been lawfully carried out. This process of greater public involvement in decisions affecting the environment as active as opposed to merely passive parties has been evident not merely within the Union but beyond. As is well known, the Aarhus Convention on Access to Information, Public Participation in Decision-Making and Access to Justice in Environmental Matters, which came into force in 2001, affects not merely the Union and its member states, but also various other states. So far as the Union is concerned, the Convention in part consolidates past moves and in part mandated new and more extensive moves to involve the public to a greater degree. Easy access to justice for those who think they have a just cause sounds manifestly desirable. I shall assume that we are here concerned with access to the law courts by everybody, and that what the law delivers, what the law courts deliver, is justice. Justice according to the law. A big assumption, some might say, but a useful one for the purpose of keeping these reflections within the bounds of the supportable. The concept of environmental cases, which I was asked to address, may cover, as you know, a whole variety of overlapping matters. For present purposes, I shall concentrate primarily on administrative law cases where the issue is whether the appropriate administrative procedures are being or have been followed. While the European Union has also been hugely active in the civil law field, enabling individuals to sue in tort for past or anticipated environmental damage to some personal interest, I shan't touch on that tonight. You may ask, what has the European Union to do with all this? There is much unease in some circles, particularly in this country, at the way what was seen by some as a purely economic European project has moved to embrace far more than it did in its early days. In this context, it is, I think, worth pausing a minute to consider why European law, has moved from being concerned largely with the four freedoms, the freedom of movement of persons, goods, services and capital, to embracing also environmental concerns, which are not to be found mentioned in the initial treaties. Is this the result of empire building by the European civil service, or does it correspond broadly to the desires of member states as expressed by their governments? Since the amending treaties and secondary legislation with which we are concerned would not have been passed without the assent of the governments of member states, it is clear that we are not here talking of some European civil service coup d'etat, and the perpetual discussion in this country of Brussels without further specification obscures a number of subtleties. There are, of course, separate questions as to whether the decisions of those governments at the time they were taken reflected the wishes of the majority of their citizens, or indeed reflect them now. But those questions are also not for today. But why has there been this governmental enthusiasm for including the environment as one of the matters within the purview of the Union? Why do we find Articles 11 and 191 to 193 of the Treaty on the Functioning of the European Union and Article 37 of the Charter of the Fundamental Rights of the European Union? Well, I think it's easily explicable and will be blindingly obvious to most, if not all of you. But let me give a few real-life examples of the type of situations which governments no doubt felt called for wider than purely national responses. Reference has been made to my house on the Moselle. Very nice it is. But I can see from my bedroom window the emissions from French atomic and industrial installations. A couple of years ago, just across the river in Germany, there was a planning application for a major quarry excavation. To my delight and surprise, through my letterbox came a request from the German planning authority, transmitted via the Luxembourg planning authorities, for my views on the matter. The Austrians, and I refer here to a case which we were concerned with, decided by a referendum some time ago to have no nuclear installations in their country at all. It was much debated, and that was the decision of the populace. And indeed, that has been stuck to and carried out. They've had this problem that a few kilometers beyond the Austrian frontier, the Czech Republic had a nuclear installation. European law lays down various safety standards in relation to such installations, and no doubt Austria is glad that it does, and that it has a right to an input into decision-making by the Czechs in these matters. The Austrian places no high value, one imagines, on any sovereign right vested in the Czechs to do what pleases them in the Czech Republic. As you know, the Irish are worried about nuclear and other emissions from England. And these concerns are absolutely typical of concerns throughout the Union. So to a Luxembourger, an Austrian or an Irishman, the advantages of having an input into what goes on abroad in the environmental field is obvious. But they should really be only marginally less obvious to those who live in this sceptred isle. Think of Chernobyl. Notwithstanding the existence of several perfectly legible signs around this country stating this is a nuclear-free zone, the results of activities and lax safety practices hundreds of miles away were felt on the hills of Wales and elsewhere. Member States felt that it was in their mutual interest each to have some input into the decision-making process of other member states. Some people take the view that the disadvantages of having other European states involved in our environmental decisions exceed the advantages. But I don't think it can be seriously doubted that there are undoubted advantages. And even such people are no doubt delighted that, things being as they are, they can have an input into other nations' decision-making process. At any rate, the fact is that it is manifest that European Union law has played a major part in this process of allowing more and more people to participate in the decision-making process. The advantages of increased public participation are of two kinds, broadly. First, it should improve the quality of the end result, because facts and value judgments known to and made by those most nearly concerned will generally, as a result of this process, have been brought to the attention of decision makers before they make their own factual findings and value judgments. And moreover, any flaws in the decision-making process are more likely to be discovered. Second, it should reduce individual dissatisfaction with the end result of the decision-making process if those whose view has not prevailed nevertheless feel confident that their opinions have, at any rate, been taken into account by the decision-makers, and if they've had an indication in the decision letter as to why their views have not prevailed. As probably the oldest person in the room, who started practicing before the 1962 Planning Act was in operation, I can tell you at that time there really was total secrecy, no, not total secrecy, but in any event, secrecy in very large areas. And the idea that you could find out why planning permission had been granted against, as you saw it, all reason, was just, you could jump. You might put it down to a conversation in the pub, you might put it down to all sorts of things, but you wouldn't know. So there are advantages in wider public involvement, but at the risk of stressing something which may not be immediately popular, it is, I think, worth pointing out the costs of wider public involvement. Because these broad considerations which I've mentioned, the increased participation by the public is in general regarded as a good thing, and I'm not to be thought of as dissenting from this view, which at the very least is seriously tenable. It is, however, worth noting that a considerable price is paid for the benefits of this public participation. I mention shortly three aspects of this. The first is that the decision-making process becomes more expensive in time and money terms. The increased expense arises from the involvement of more and more people for more and more time in more and more processes at private or public expense. More people, most of whom are paid, examine more paper, inquiries are set up which take a long time, resort to the law court, which also takes time, has to be paid for. There's a further aspect of expense. The developer is bearing interest charges while time is passing. The inevitable result of spending more money on this process of public involvement and consultation is that less money is available to spend on goods and services which the public also desires. A second and similar matter is that while civil servants and judges are examining these environmental cases, they're not available to do other things which the public requires of them. When I was judging planning cases, somebody was waiting in prison till I could come to him and deal with his complaint that he was unjustly in prison. A third is that the decision-making process, which doesn't finish until the last opportunity for legal challenge has gone, takes longer. An inevitable result of the delay is that those who would benefit from the existence of the proposed development are deprived of those benefits whilst the process of examination is going on. I must express myself cautiously, but I can, I think, say this. Where the law leaves a certain margin of discretion to a decision taker, be he legislator or administrator, be he layman or judge, then sometimes the decision taker can legitimately weigh the benefit of a particular step against the price which needs to be paid in order to achieve that benefit. That is what we've all got to know as the principle of proportionality. I turn now to the question of publicity and the central directive on this matter with which many of you will be familiar. The involvement of more and more people in the decision-making process on environmental matters is notably mandated and facilitated by a number of directives and regulations. The most significant of these in the European Union are the Environmental Impact Assessment Directive of 1985, which, following the Aarhus Convention to which I have referred, was significantly amended in 2003 and is directed to member states. And also regulations 1049 of 2001 and 1367 of 2006, which apply, broadly speaking, the same sort of principles to the Union's institutions. The amended directive provides in Article 2 that member states shall adopt all measures necessary to ensure that before consent is given, projects likely to have a significant effect on the environment by virtue, inter alia, of their nature, size, or location, are made subject to a requirement for development consent and an assessment with regard to their effects. It mandates and harmonizes the principles of environmental impact assessments throughout the Union by introducing minimum requirements, in particular as regards the types of project that should be subject to an assessment, the main obligations of the developers, the content of the assessment, and the participation of the competent authorities and of the public. The directive first mandates screening procedures under which applications which may have significant effects on the environment are screened in order to see whether an environmental impact assessment is required. And secondly, it provides for the transposition into national laws of various prescriptions as to how such impact assessments are to be carried out and how outcomes may be challenged. And this directive has been transposed into the law of all member states, including, of course, our own. The regulations give the public rights to reasons for decisions and to the underlying documents. The result of this has been that the public has become more and more involved in the planning process, and this is a point which may not have occurred to you, but is perhaps significant, the ex-communist member states of the Union report that the directive has contributed to consolidating democratic development by improving public participation and transparency in decision-making. This is something one is very conscious of when you sit, as I do now, with half a dozen judges who've emerged from communist dictatorship, and for that matter also, I suppose, fascist dictatorship elsewhere in the Union. And one notices that people who've come from that background are very much more sensitive to issues of openness and discussion with the public than certainly we were in this country when I was a lad. And they think that it helps them become democracies in a way that we are used to. Lord Hoffman, you recall, said in Berkeley and Secretary of State for the Environment some 10 years ago, the directive requires not merely that the planning authority should have the necessary information, but that it should have been obtained by means of a particular procedure, namely that of an environmental impact assessment. And an essential element in this procedure is that what the regulations call the environmental statement by the developer should have been, quotes, made available to the public, and that the public should have been, quotes, given the opportunity to express an opinion in accordance with Article 6.2. As Advocate General Elmer said in the European Court, and here Lord Hoffman is quoting, it must be emphasized that the provisions of the directive are essentially of a procedural nature. By the inclusion of information on the environment in the consent procedure, it is ensured that the environmental impact of the project shall be included in the public debate, and that the decision as to whether consent is to be given shall be adopted on an appropriate basis. End the quotation from Advocate General Elmer. But carrying on with Lord Hoffman, he said, the directly environmental right of the citizen, which is accorded by the directive, is not merely a right to be fully informed, a right to fully informed decisions on the substantive issue. It must have been adopted on an appropriate basis, and that requires the inclusive and democratic procedure prescribed by the directive, in which the public, however misguided or wrong-headed its views may be, is given an opportunity to express its opinion on environmental issues. End of quotation. We know that the principle that only projects liable to have a significant effect on the environment should be subject to the full impact of an EIA is easy to accept. A major problem, however, has been the difficulty of establishing, prior to the carrying out of the impact assessment, whether the project is liable to have a significant impact. This is the screening process. The directive starts by identifying in its first annex certain projects which are of such magnitude that they must, in principle, be the subject of an EIA. Oil refineries, nuclear establishments, various large industrial establishments, constructions of long roads, rail links, etc. This has given rise to a fair amount of litigation concerned with what happens if a large project is disguised as two smaller projects which escape the annex. What happens if two smaller projects grow to become one large project, and so on. Inevitably, complex provisions such as these, the result of many months, if not years, of negotiations, will result in obscure wording from time to time, and national and community courts deal with those problems as they arise. It's all fairly normal type of challenge for a judge. More difficult has been the second annex to the directive, which lists projects in respect of which member states can determine whether or no an environmental impact assessment is to be held. The tension here is between the desire by the Union that member states have a discretion and the desire that this discretion should be reasonably and foreseeably exercised in a way which corresponds with the broad objectives of this legislation. You can see the tension, and we get it in all sorts of different fields of European Union law. Yes, this is for member states, but Union has said that the following objectives are to be obtained. If member states exercising their discretion say, well, no, there shall be no impact assessment in respect of any project covering less than 50,000 square miles, which isn't, I mean, that sounds rather silly, but in parts of Scotland, it's not quite so silly. Then the Union is likely to interfere. In case 42707, Commission against Ireland, the ECJ pointed out that pursuant to Article 4.2 of the Directive 85/337, member states are to determine for projects in the classes listed in Annex 2 to that directive through a case-by-case examination or by the use of thresholds or criteria, whether or not those projects are to be made subject to an environmental impact assessment. According to that same provision, the Member States may also decide to apply both procedures. So there we are, all for Member States. But the Court went on that although the Member States have thus been allowed a measure of discretion in specifying certain types of projects which will be subject to an assessment, or to establish the criteria or thresholds applicable, the limits of that discretion are to be found in the obligations set out in Article 2.1 of the directive, that projects likely, by virtue inter alia of their nature, size or location, to have significant effects on the environment, are to be the subject of impact assessment. A member state which establishes criteria or thresholds at a level such that, in practice, an entire class of projects would be exempted in advance from the requirement of an impact assessment, would exceed the limits of its discretion unless all projects excluded could, when viewed as a whole, be regarded as not being likely to have significant effects on the environment. All I can tell you is that in my experience as a judge in Luxembourg, and a rather shorter experience sitting as an ad hoc judge in Strasbourg, the tensions between letting local people make judgments as to the environmental value of a particular site and the strong feeling which certain cases can excite that this is perfectly obviously going to have a huge effect. What are they doing by saying that it doesn't require environmental impact assessments? Broadly speaking, the same sort of tensions that face a Court of Appeal judge when faced with a value judgment by, or a factual judgment by the judge of first instance, which he just feels in his heart is manifested drivel. I mean, these cases I need hardly add, extremely rare, but that type of tension we have in our court all the time, and some of you will be familiar with some of the cases which have gone to the court and come back here, such as Barker. You will not be familiar with the hours of sweat and blood spent arguing the toss about things of that nature. Let me pass on now to reasons for decisions and access to documents. As I mentioned earlier, one of the things which was noticeable by their absence when I started practice in England were provisions requiring the giving of reasons and provisions giving you access to documents before any proceedings had started. If your neighbour was granted planning permission against all existing expectations and policies, there wasn't much you could do about it. The planning authority wasn't required to give reasons or to produce any documents which had influenced its decision. Now, access to these are clearly useful tools enabling access to justice. Now, the Union has always been much firmer in its insistence on the giving of reasons, both by its institutions and by those carrying out Union policies. This is well illustrated in the context of environmental impact assessments by case 75 of 08, the Queen Miller against Secretary of State for Communities and Local Government. There, the court was asked, you may recall, whether or not it was necessary to give reasons for the determination made by the competent national authority not to proceed to an EIA when evaluating a request for development consent to build a project falling within Annex 2 of the directive. And the Secretary of State had simply said, well, I don't consider that the project would have a significant effect on the environment. Schluss, as they say in Germany. That's that. And he therefore directed that he didn't consider it was an EIA development, with the consequence that any permitted development rights were unaffected. The history of the case is rather complicated and doesn't matter. But the ECJ pointed out that in an earlier case it had stated that the determination by which the competent authority takes the view that a project's characteristics do not require it to be subjected to an EIA must contain or be accompanied by all the information that makes it possible to check that it is based on adequate screening carried out in accordance with the requirement of Directive 85/337. The court referred to this earlier case and continued, and the subtleties here are actually quite worth following as you proceed them, and they reflect different traditions in different member states as to the degree of access to reasons. And there's a huge spectrum of views amongst member states. It does not follow, said the court, that a determination not to subject a project to an EIA must itself contain the reasons for which the competent authority determined that an assessment was unnecessary. In short, I interject to comment on the decision. The court accepted that in many cases it will be perfectly sensible to say that without giving a lot of reasons. It is apparent, however, the court continued, that third parties, as well as the administrative authorities concerned, must be able to satisfy themselves that the competent authority has actually determined, in accordance with the rules laid down by national law, that an EIA was or was not necessary. Furthermore, interested parties, as well as other national authorities concerned, must be able to ensure, if necessary through legal action, compliance with the competent authority's screening obligation. That requirement may be met, as in the main proceedings, by the possibility of bringing an action directly against the determination not to carry out an EIA. In that regard, effective judicial review, which must be able to cover the legality of the reasons for the contested decision, presupposes in general that the court to which the matter is referred may require the competent authority to notify it of its reasons. However, where it is more particularly a question of securing the effective protection of a right conferred by community law, interested parties must also be able to defend that right under the best possible conditions and have the possibility of deciding with a full knowledge of the relevant facts whether there is any point in applying to the courts. Consequently, in such circumstances, the competent national authority is under a duty to inform them of the reasons on which its refusal is based, either in the decision itself or in subsequent communications made at their requests. That subsequent communication may take the form not only of an express statement of the reasons, but also of information and relevant documents being made available in response to the request. And so the court held that the directive didn't require that a determination that it is unnecessary to subject a project to an EIA should itself contain the reasons for that decision, but if an interested party requested it, he was to be provided with material and relevant information which would give him the relevant material. It said that a determination is sufficiently reasoned where the reasons which it contained, added to factors which have already been brought to the attention of interested parties and supplemented by any necessary additional information that the competent national administration is required to provide to those interested parties at their request, can enable them to decide whether to appeal against that decision. And I hope you feel that there's a reasonable compromise between differing and warring considerations. Can I turn to the matter of standing and costs? I note at the outset that the Commission has no standing problems. It can and does bring infringement actions, of which some 20%, I think, currently are environmental cases. So it does actually beaver on behalf of the public, sometimes after a certain amount of time. But in this field of standing, the liberality of the English has had an influence, and union law, both in the specific field of the environment and indeed more generally, has become more generous than it was in questions of standing. The problem here is that the more people are entitled to have an input at every stage of the proceedings, the slower and more expensive the process is likely to be. It's clear, however, that the whole drift of the legislation and the case law over the last years has been to give more and more people opportunities to make their contributions both before and after the primary decision is taken. And it is perhaps noteworthy in a wider context that Article 230 EC, governing access to the community courts by individuals and legal associations, which had been restrictively interpreted by the ECJ, if not by its advocates general, has been replaced by Article 263 of the Treaty for the Function of the European Union, which is differently phrased. What effect those changes have in practice remains to be seen. Academic opinion, as always, is divided. The question of standing arises both before and after any possible court process, but I shall concentrate on the right to access to the court process itself. Again, the traditions of member states are widely divergent, varying from the very restrictive to the extremely generous. And the relevant provisions of the 1985 directive as amended, as found in Article 10A, whose wording bears witness to the difficulty of reconciling the irreconcilable. Those of you who have had a look at it will be familiar with the type of problems. I just give you an excerpt to give you the feel of it. Member states shall ensure that in accordance with the relevant national legal systems, members of the public concerned, A, having a sufficient interest, or alternatively, B, maintaining the impairment of a right where administrative procedural law of a member state requires this as a precondition, have access to a review procedure before a court of law to challenge the substantive or procedural legality of decisions, acts, or omissions, subject to public participation provisions of the directive. Everything is subject to something else and across subject to something else. What constitutes, same conflict you will see, as I mentioned earlier on, what constitutes a sufficient interest and impairment of a right shall be determined by member states, consistently with the objective of giving the public concerned wide access to justice. To this end, the interests of any non-governmental organizations meeting the requirements referred to in another article shall be deemed sufficient for the purposes of this article. Such organizations shall also be deemed to have rights capable of being impaired for the purposes of another bit of the article. And then there's a line which will please you all. Any such procedure shall be fair, equitable, timely, and not prohibitively expensive. So I'm glad to hear of the moves made by Konrad Chance. Now, this provision is essentially based on Article 9 of the Aarhus Convention, or part of it, and has given rise to a fair amount of litigation, some currently in a process under debate in my court. But I can quote from a case quite recently which has been decided, which bears the name, Danish speakers must forgive me, Djurgården Wirtans Milieusködsføring. One of the points which the court was concerned was the standing to sue of the plaintiff environmental organization. And it's a case, again, which typically illustrates the tension between the desire to leave some matters to member states and yet so to organize matters that the relevant union provision, that member states are not free to sidestep the very aim of the union provision. The court said this. By its third question, the referring court asks essentially whether in the context of the implementation of Article 10A of the directive, member states may provide that small, locally established environmental protection associations have a right to participate in the decision-making process referred to in Article 2.2 of the directive, that's the earlier process, but no right of access to a review procedure which challenges the decision adopted at the end of that process. Now, it's quite interesting. It's the precise opposite of the sort of situation we have in this country, where you say, well, if you had an input at the inquiry, well, certainly you can have a shout before the court. The argument there was, look, you've done your bit, you've been given a chance, you've had your shout. The court really, that's not for you. The court continued, it's clear that the reason for that question is the existence in the relevant national legislation of a rule that only an association with at least 2,000 members may bring an appeal against a decision adopted on an environmental matter. It's clear from the directive that it distinguishes between the public concerned by one of the projects falling within its scope in a general manner, and on the other hand, a subgroup of natural or legal persons within the public concerned, who are entitled to challenge. The directive leaves it to national law to determine the conditions for the admissibility of the action, and then those are set out. As regards non-governmental organizations which promote environmental protection, the directive, read as a totality, requires that those organizations meeting any requirements under national law are to be regarded as having a sufficient interest, or as having a right which is capable of being impaired, which is the other route to the court, by projects falling within the scope of the directive. While it is true, says the court, that Article 10A of the directive leaves to national legislatures the task of determining the conditions which may be required in order for a non-governmental organization which promotes environmental protection to have a right of appeal under the conditions set out, the national rules thus established must first ensure that wide access to justice, and second, render effective the provisions of Directive 85 on judicial remedies. Accordingly, those national rules must not be liable to nullify community provisions which provide that parties who have a sufficient interest to challenge a project and those whose rights it impairs, which include environmental protection associations, are to be entitled to bring actions before the competent court. It is conceivable, said the court, that the condition that environmental protection association must have a minimum number of members may be relevant in order to ensure that it does in fact exist and that it is active. However, the number of members required cannot be fixed by national laws at such a level that it runs counter to the objectives of the directive, and in particular the objective of facilitating judicial review. In that context, it must be stated that although the directive provides that members of the public concerned who have a sufficient interest in challenging projects are to have the right to challenge the decision which authorizes it, that directive in no way permits access to review procedures to be limited on the ground that the persons concerned have already been able to express their views in a participatory phase. That's the first question that was asked there. The court went on, the directive doesn't exclusively concern projects on a regional or national scale, but also projects more limited in size, which locally based associations are better placed to deal with. And the rule of the Swedish legislation at issue, it's Swedish case, is such as to deprive local associations of any judicial remedy. So the court said broad rule of 2,000 won't do. I've been hoping to deliver this lecture rather later to tell you the result of some more recent cases, but the solemn oath I swore not to reveal the secrets of the deliberate prevents me from doing so. But there is a case before the court at the moment in which there has been a hearing and the opinion of the Advocate General is awaited. It's concerned with the standing of an environmental association which seeks to argue a case basically on behalf of the environment at large, rather than in respect of the rights of various individuals living in that environment. The issue there concerns a preliminary decision and a partial permit in respect of a coal-fired power station in Germany. It's a case called Bund für Umwelt und Naturschutz, 115 of 09. The Germans, as you may know, have a rather restrictive approach to standing, and in general you can challenge an administrative decision only if you can show that your personal rights are at risk of being affected. This restrictive approach in Germany is balanced, as they maintain, by a particularly intensive scrutiny by the court in the judicial review proceedings brought by those who do satisfy the test as to standing. By contrast, we in England have a more generous approach to standing, but perhaps, at any event, in some context, a less intense scrutiny of the underlying merits of the case. This is typical, again, when you start doing comparative law, you find that there's a very nice rule which you say, well, that works very well, but it's in a different context. And it is very difficult to move things from one country to another. There are several cases concerning the rights of NGOs of access to the courts and various other questions before the courts at the moment. So watch this space. There will be more coming out within the next few months from my court. So let me, before closing, finally draw attention to the directive provisions relating to clarity of legislation and costs, which are potentially very significant, not least in this common law country, where much of the law concerned is in judicial decisions, and where, from the point of view of most member states, legal costs are extraordinarily high. My colleagues are absolutely staggered, A, at the quality of the British advocates who appear in front of them, B, at their enormous cost. Those of us who earn our bread and butter in this field say, well, the two are not wholly unconnected. But I don't know, do you remember I drew attention to this sentence in Article 10 of the directive: any such proceedings shall be fair, equitable, timely, and not prohibitively expensive. In the Irish case to which I referred earlier on, the court held that the provisions of a directive must be implemented with unquestionable binding force and with the specificity, and I tell you this, my last quotation, end of lecture, with the specific, just as well, specificity, precision, and clarity required in order to satisfy the need for legal certainty, which requires that in the case of a directive intended to confer rights on individuals, the persons concerned must be enabled to ascertain the full extent of their rights. In that regard, it's clear from Article 10a that the procedures established in the context of those provisions must not be prohibitively expensive. That covers only the costs arising from the participation in such procedures. Such a condition doesn't prevent the court from making an order for costs, provided that the amount of those costs complied with that requirement. A national practice under which the courts may, and this may surprise you, a national practice under which the courts may decline to order an unsuccessful party to pay the costs, and can, in addition, order expenditure incurred by the unsuccessful party to be borne by the other party, is merely a discretionary practice on the part of the courts, and such a practice on the part of the court, which cannot by definition be certain, cannot be regarded as a valid implementation of the obligations arising under those articles. Well, I certainly made orders like that in my time, and I suspect some others here have too. In addition, the 6th paragraph of Article 10A laid down an obligation to obtain a precise result which the member states must ensure is achieved, which consists in making available to the public practical information on access to administrative and judicial review procedures. In the absence of any specific statutory or regulatory provision concerning information on the rights thus offered to the public, the mere availability through publications or on the internet of rules concerning access to administrative and judicial review procedures and the possibility of access to court decisions cannot be regarded as ensuring in a sufficiently clear and precise manner that the public concerned is in a position to be aware of its rights of access to justice in environmental matters. And I leave you with that thought.
Thank you very much, Konrad, for that fascinating insight into these issues and leaving us on the sort of waiting with excitement for the next instalment. But we've just got, I think, 10 minutes or so for questions, if anyone has any questions for Sir Konrad. Ah, yes. Professor McCrory.
Thank you very much. That was a great lecture. Both the Aarhus and the directives talk about the right to challenge before a court or tribunal on the basis of substantive or procedural illegality. And I know there are some views who say, well, that should be equivalent to a full merits review. And I think even the Aarhus Compliance Committee have hinted at that. I don't think that's the case myself. But I wondered whether you think, is it the same as a judicial review, or is it actually requiring something a little bit more intense by the courts? I mean, is there a distinction between that, or is it just reflecting whatever is the practice in the courts, as you say, which is different across the community?
Yes, I'm afraid I'm going to give an utterly unhelpful answer. The problem being that amongst the 27 member states, there is a huge variety of approaches to what is a common problem to the all. The court isn't the decision maker, but on the other hand, it must have a right to interfere at a particular point. And certainly sitting in my court, which is rather different, I actually don't face that problem very much, because it's the national courts which have that problem. You're given nice abstract questions, which we usually make more abstract and give abstract answers. That's rather easier than deciding cases. But as to the degree of scrutiny, as I was pointing out, there's a tension between who has the right to have the decision scrutinized and the intensity of the scrutiny. And I think the more widespread the right is to come to the court, the less the court will be inclined, and I say the court, I mean the national court rather than my court, the less the court will be inclined to get stuck into the merits of a particular planning decision. Sorry, that's not very helpful, but you could see the correlation between the two things. Whereas in Germany, particularly in constitutional cases, once you've got standing there, the court goes into the case with a degree of detail which is would be very surprising to most of us sitting here. But they only do that because they shoot most people out at the preliminary hurdle.
Yes, back there, yeah.
Rafe Smith, Campaign to Protect Rural England. I'd like to ask how to improve access to justice where a major infrastructure decision has been taken by an act of the legislature. For example, in the UK, a hybrid bill, where there won't be reasons given, where the decision makers won't necessarily have expertise in planning major infrastructure, and where some of the safeguards of the directive don't apply? Do we need to front-load public participation, as the innovation in France through the Commission for Public Debate has done? Or do we need to ensure that Parliament only looks at high level of principle, and then there's a further procedure for an independent expert to work out the detail?
Well, these are policy choices which have to be made by each country. I haven't any very strong views on that matter. I mean, you saw, as I talked, the balancing considerations one always has. But it's my understanding, and I'm a little bit out of touch with this country, but my understanding is that we have moved in the last few years towards taking some things away from public inquiries and letting Parliament effectively decide the point, which is a democratic way of approaching the matter. And we mustn't forget that the separate problems related by the House of Lords, but Parliament in principle is democratically elected, and it can be said that is the democratic input. Manifestly, it's up to Parliament to decide how much democratic input it wants. That said, I don't rule out, even with the legislative process, an interference by the European Commission, which is an extremely eager beaver person in the environmental field. I mean, stones are not left unturned, and they've admittedly not always succeeded in front of our court, but they quite often succeed, and they certainly have plenty of vigour.
Thank you. Yes, here.
Thanks. Mothri Rahman, Bertram Dyson Bell. I was just interested in the decision-making process after final submissions have been made, in terms of the 7 judges and each having different languages and different jurisdictional practices. Is there an open, transparent method by which you come to your decision, or is it over?
The short answer there is no. Let me put it this way. The method is perfectly open and transparent. But actually what was said during the course of it is not. But I'll tell you how it works. First of all, we all work in French, because we've got to have one language in which we can all work. We work without interpreters. So we all work in French. All the documents coming from Finland and Portugal and Greece and so on are all translated into French. So we've at least got a common text. And we work in French. A judge, the reporting judge, does a draft judgment which he circulates amongst all the other people who are sitting, who may be anything from 3 to 35. Now, just this morning, it's very seldom we sit with 35, but as a matter of fact, I, at the moment on such a case, was only this morning looking at very many submissions from very many different people. The reporting judge receives all those, and then he may make an amendment to his judgment to take into account some of them, or his draft judgment. That will then be discussed at a hearing, but private hearing, and we will discuss, and that we are under an obligation to give reasons for our judgment. The problem is this, and it's an insurmountable problem, that even on the assumption that we are all agreed that the end answer should be so-and-so, we may have different approaches as to how one should get there. Approach A, approach B, and approach C. And the A protagonists regard B and C as misguided, the B regard A and C as misguided, and C thinks A and B are misguided. So the only majority one can find is that the others are misguided. This doesn't happen very often, but forms of this happen all the time. We try and reach a broad consensus to shy away from things which people are not happy with, by and large. Sometimes that can't be avoided, but by and large, if we have a case where we are seriously divided right down the middle, rather than deciding it on a vote, we tend rather to avoid the question and produce one of our more obscure judgments. It's all very well for you to laugh. It's not all that easy to do. You've got to work with these colleagues, And they come with different traditions, different self-evident truths we all have. We do genuinely learn from each other. I mean, I think it's astonishing how well the process works. I mean, I poke fun at it because it gets a laugh. But it does work reasonably well 80% of the time. And one's got to come to a decision. And the difficulty is, of course, everybody wants to elaborate their viewpoint. And the more of you there are, the bigger cases have 13. And 27 is very rare, but 13 is perfectly common. And those are the important cases on the whole. And people all want to have their say. And it is very difficult to keep your attention focused hour after hour in another language, being spoken not by a Frenchman, but by a Finn speaking French, followed by a Greek speaking French, followed by an Englishman speaking French. This is all very difficult.
Can I
just ask you a follow-up quick? I mean, you, in an environmental law audience, you have an extensive background in environmental law, but I suspect a lot of your colleagues don't. I mean, to what extent does that assist, or is that in fact, or does it enter into the balance at all?
Well, the cases, when they come into the court, are allocated to a so-called reporting judge, whose job it is effectively to take charge of the case, to do the draft judgments, and then alter it. And the choice of the reporting judge for cases is within the president of the court. And he tends to choose horses for courses, rather than the way that, to some extent, the Court of Appeal does. But you try to get people who are familiar with the field. That has the disadvantage that a chap with a particular bee in his bonnet can start having a major influence on European law, because the others say, well, he knows about this, but, and we don't. The Court of Appeal has the same sort of problem. No, Lady Arden shakes her head.
Good. I think just one more question. Yes.
I was fascinated by the concept of a strict idea of standing and then intense scrutiny once you've got through the standing. What's the logic of the connection between the first and the second?
I think the whole German tradition for a long, long time, which perhaps informed a misguided dictum of mine in a case called the Rose Theatre many years ago, an occasion when I attracted almost unanimous condemnation. But I only did it because Jeremy Sullivan, sitting in front of me, threw this bonbon in my direction at the end of term. And I thought, oh, well, let's have a go at this. And I've just been reading about German law. The German tradition is to be very restrictive of standing, much more, and they take it seriously, which we don't really, the question of standing. But if you're dealing with constitutional rights in Germany, because of their Nazi history and other, constitutional rights are desperately important, and the court will take immense care over it. And I think that is why, I mean, it isn't actually specifically a connection which is built up because of that connection. Two factors have arisen entirely separately from one another. I linked them together because the Germans linked them together in order to justify their stance in a particular case.
Right. Well, I think on that note, we will end this session and say an enormous thank you to Sir Konrad for coming here to talk to us and being so frank. I mean, the next time you're struggling with an incomprehensible European judgment, try and picture the group of them struggling between speaking French from a Finnish and a Greek and even a sort of a Bulgarian perspective, and say what a remarkable thing is that it's come out, well, in English actually, I'll probably read it. It's an extraordinary thing. But it's been very, very kind of you to come. I mean, you don't know that Konrad actually fell down a staircase in Madrid only a few days ago, and happily has bruised himself, but he's actually been very kind to come here and indeed to stand to talk to you. So a great note of appreciation for our speakers.